On demand whenever you need it. Fox 61 News on Roku and Amazon Fire TV. Search Fox 61 and download the app today.
This morning, a Real Story special. Jennifer's Law is now in effect here in Connecticut, providing better protections for domestic violence victims. But with it, concerns about its implementation. Will it be effective? Our in-depth conversation with those on the front lines of this new law. Family violence victim advocate Colette Donnelly will update us on her work helping guide domestic violence victims. How often is Jennifer's Law being used? Plus, attorney Alex CUDA, the chair of Connecticut Bar Association's Family Law Section, will tell us what he's seeing in the courts. Then, Associate Professor of Criminal Justice at University of New Haven, Mike Lawler, will give us his take from his years of legislative and policy experience on the challenges and the process involved in the judicial system implementing new laws, such as Jennifer's Law. It's all today on The Real Story. Good morning, and thanks for joining us on The Real Story. I'm Jen Bernstein. A law nicknamed Jennifer's Law has been on the books since October 1st. Its intention is to help save lives, giving domestic violence victims more tools to fight back against a controlling relationship before violence happens. It comes with hope, empowerment, anxiety, and concern on how this new law will be interpreted by attorneys, the judges, and even the victims themselves. Today, we are doing a deep dive into the law. Here's a look at how Jennifer's Law is being viewed just a couple of months after becoming the law of the land here in Connecticut.
It's been very stressful. It's been very stressful for my kids.
This Simsbury mother of three, who we'll call Sarah, is going through a difficult divorce, all while trying to clear her name from a large amount of debt. Debt she says was created by her husband without her knowledge.
I had over $230,000 of credit card debt in my name.
Sarah has a law degree but was a stay-at-home mom during her marriage. And now she says with no credit score, she's still beholden to her estranged husband financially. And with family court facing delays because of COVID, she's having trouble seeing an end in sight.
I don't have the ability, as a result of financial abuse and or coerced debt, to go get a lease on a car.
But a sign of hope recently when a bill nicknamed Jennifer's Law went into effect October 1st. Sarah is one of many who are hoping she can now access protections that weren't there before. The law is more than 40 pages long and includes a number of measures to help domestic violence victims. But the expanded definition of domestic violence to include coercive control is the newest concept. It's defined in the law as a pattern of behavior that in purpose or effect unreasonably interferes with a person's free will and personal liberty. It's not physical violence, but can include behaviors like isolation, monitoring, threatening, or financial abuse. Jennifer's Law was named after Jennifer Dulos and Jennifer Magnano. Dulos, a mother of five, has never been found. Her estranged husband, Fotis Dulos, was charged with her murder, but took his own life. Jennifer Magnano was shot and killed by her estranged husband in front of their children when she went back to the home they shared. But with any new law, there's questions and concerns. Victims' rights groups like Connecticut Protective Moms, while glad it's on the books, are worried on how it will be interpreted.
But the problem now is how to implement that law.
Coercive control has not been understood in the community, in the court system.
Attorney Michelle Cruz wrote the report on Jennifer Magnano's tragic death when she was the state victim advocate in 2007. That report highlighted the systemic failures in both the civil and criminal justice systems. And she says this wasn't the only case.
The courts have not been able to keep them safe.
She believes educating the courts and attorneys on coercive control is key.
We're sort of in the public awareness phase and the training phase.
The Connecticut Coalition Against Domestic Violence has trained hundreds of people who may encounter a victim, like judicial employees or health professionals. But what about coercive control training for judges, the ultimate decision makers in these complex cases? We did reach out to the judicial branch to participate in this story. They declined an interview, but they did give us this document, which lists off the domestic violence-related education required for judges. The document showing in 2021 there was a program on coercive control and its impact on children and adults. The branch saying in a statement to us, judges' training on domestic violence is extensive, regular, long-standing, conducted by leading national experts in the field, and is in addition to other resources available to a judge. The branch also informing us additional training on coercive control is planned for 2022. But one court advocate is telling us Jennifer's Law is already working. Colette Donnelly advocates for victims at Rockville Superior Court.
Over the past month, I'd say I definitely have had more than 6 restraining orders that were granted just on Jennifer's Law.
What we're looking at is the possibility that we could maybe get somebody safe before they're hurt.
It will likely take longer to see how Jennifer's Law plays into complex custody and divorce cases, according to attorney Alex CUDA. That's because of a serious case backlog due to COVID.
It has been very much a challenge, for litigants, for lawyers, for the courts.
CUDA says the Connecticut Bar and the judicial branch are working to find ways to alleviate the logjam.
And it's a shame to see, that law or any law not be able to protect people the way it's intended just because somebody can't get into court.
And back to Sarah, whose divorce case has been dragging for over 18 months. She started practicing law again and has been able to clear her name with several banks who, according to paperwork she showed us, confirmed she was the victim of identity theft. Where is your faith in the court system at this point?
I want to believe the courts are going to do the right thing for everybody, but it really is going to all be based on whether everybody is educated and willing to, across the board, follow it.
Now, recently, Sarah says that she applied for a restraining order under Jennifer's Law, becoming fearful after she says her husband purchased a gun. She tells us that restraining order was denied. Ultimately, this law will be molded over time through the work of attorneys and the interpretation from judges. At this point, all sides are in agreement that understanding and being educated on the concept of coercive control is what is going to really save lives. So let's go more in depth with this issue. I want to bring in 2 people from this Jennifer's Law piece you just saw. Alex CUDA, the chair of the Connecticut Bar Association's Family Law Section, also an attorney himself, as well as Colette Donnelly, a family violence victim advocate with the Network Against Domestic Abuse. She helps victims out of Rockville Superior Court. Thank you both for once again taking the time and joining me to discuss this important issue.
Thanks for having us.
Of course. All right, Colette, I want to start with you because you had such an interesting perspective because you're really on the front lines and seeing these restraining orders going through. So first of all, can you just tell people what a victim's advocate does? What do you do every single day when you go into work?
Right. So I work out of the Rockville Superior Court, so I help with the criminal arraignments for domestic violence matters. But then on the civil side, I'll help victims of domestic abuse with applications, with getting an attorney. If they can't get an attorney, I'll attend the hearing with them and be there as support.
And coercive control, I mean, now we've kind of coined the definition, but this is something that in your position you've seen for years, right? It's not new for you. It's just the fact that it's on the books now gives domestic violence victims new tools that they didn't have before.
This is not new behavior. It's just definitely new to how victims of domestic abuse can seek help.
So tell us what you're seeing. So this story, I think I interviewed you last month. The story also aired last month. And, I think the law had only been on the books for about a month. Update us on what you're still seeing in court.
Thank you. Yeah, so I recently have had a lot of financial abuse. Most of the cases that I've had recently have included threats of self-harm if the person were to ever leave them, especially after the relationship is over. I see a lot of, please come back, or I'm going to do this, or just kind of intimidating or threatening harassment behavior to get the person to come back into the relationship. One recently that I don't see very often is threats towards pets, but I just recently in the past few days had a restraining order where it was granted, and one of the factors of the restraining order was a threat towards a family pet. So this law is all-encompassing. It kind of just is a blanket for all different types of coercive and intimidating behavior that could force a victim into staying in a relationship if they weren't to comply with their abuser's demands.
And so obviously Rockville Superior Court has taken this law, has decided, to interpret it, and it's being used for these restraining orders. Jennifer's law, restraining orders are being granted under Jennifer's law from what you've seen.
Yes, more on the uptick than before, definitely. And I had one recently that I spoke with just in the past week where she said, I've been in this relationship for a decade, and no one ever took me seriously up until this law was granted, and now I can finally get some legal help. And this is the reason why I'm able to get this restraining order, because before I didn't have a voice. So it's definitely been helpful for victims of domestic violence.
Interesting, Colette. All right, Alex, I want to bring you in because you brought up such an important point in your story. This law is only as effective as it being heard in court, right? So it's a little bit confusing here, but a lot of the emergency docket restraining orders, what Colette was doing, those are going through, right? But for longer, complex cases, custody cases, divorce cases, those are held up, and it's pandemic related. So tell us what you're seeing.
Sure. So, I'm a private attorney practicing primarily, in the Stamford Superior Court, Bridgeport Superior Court, and Danbury Superior Court. But with my work with the Connecticut Bar Association as chair of the family law section, I have the opportunity to, hear from lawyers from throughout the state. So I don't think it's unique to the places that I practice. I think, we have sort of a situation, that's been created throughout, every reach of the state, every, socioeconomic level. That is affecting, the court system and access to justice. So, I want to emphasize that, to the extent that I mentioned a backlog, the courts have been open, remain open, for emergency motions. That is something where if somebody needs to file a restraining order, emergency custody application, that can happen very quickly. So I know I want to dissuade anybody, from, going to the court, right away if they have an emergency need, because there's a priority one docket specifically, for those matters. But there's sort of a short-term and a long-term aspect to this. And it's the long-term aspect, which is, I think, really impacted by the backlog here, where you have, all these cases which have built up over the course of the pandemic, while, the courts have been, working to try to, address how they're going to hear things, remotely or otherwise. And it's a serious problem. It's an access to justice problem for people to be able to get into court and have, their custody applications come to a final judgment, or their divorce cases come to a final judgment. And so for those purposes, the extent to which Jennifer's law is really going to affect those matters, will really take some time to be seen. On the other hand, I think, it's a law that's happened at exactly the right time, because it does expand the scope, really, of what the court can do in these short-term emergency matters. And quite frankly, even before Jennifer's law passed, there was a much more vigorous, I think, emergency motion practice, because that was the way to get into court right away. And so I think now that Jennifer's law has expanded the scope, in terms of recognition of coercive control. It's not a new concept, but I think it is something that's now is codified. It's outlined in our statutes as to a general standard for what this means. And so it's happening at exactly the right time for the courts then to be able to address a broader scope of issues in emergency motions. Now, the judicial branch and the Connecticut Bar Association have been working together in an ongoing conversation about that, and in terms of how the judicial branch is going to improve the process, improve the access to justice problem that's going on. And just even very recently, the judicial branch has made a new communication available to the bar, to those who are practicing, in terms of how it's going to be increasing the speed with which it addresses matters that are brought to it. Specifically, resolution plan dates and this new pathway system. The court has rolled out a new system, sort of triaging these matters, and so the court and the bar are having this with, we hope is a productive conversation in terms of how to best serve, family court litigants, throughout the state.
So you're saying that judicial branch is updating the Connecticut Bar, and they say they're trying to alleviate that backlog, and they're taking certain actions in the new year to try to do that.
Absolutely. I mean, and it's been, a conversation that's been going on for a while now, even during the heart of the pandemic, the bar reaching out not only on behalf of its membership, but on behalf of the clients we serve, the people, who need access to justice and their children who are severely impacted by this. I mean, that's the point of a lawyer, after all, is to try to serve these people, protect them, protect their children, and to have a communication with the judicial branch about how to improve the problem. I think everybody recognizes there's a problem. Different people disagree about what the solutions are, the nature or scope of it, but there is an ongoing conversation between the bar and the bench, the judicial branch, to try to improve this. And so far, fingers crossed, I mean, it seems like the branch is listening to the issues that have been presented to it and trying to improve the situation.
It is, and these are people's lives that we're dealing with, right? Because let's say you have someone who's in court who is trying to file a motion to get child support or anything like that, that's maybe not an emergency motion, but does impact their lives, their livelihood, how they're trying to do their day-to-day work for their children, and they can't, and the other spouse isn't responding, right? You need the court to be able to step in and force the issue, and you can't at points. And so these people are waiting long periods of time to get someone to even comply if you have two parties that aren't agreeing.
Absolutely. That's the crux of the problem where, one would hope that everybody gets along and, it is obviously better if people can reach agreements and sort things out. But there are so many matters where they can't, and especially where children are caught in the middle. And especially if you have one financially advantaged party, delay can really work to the disadvantage of the non-financially advantaged party. If you have a motion for child support, for alimony, for custody, and it doesn't get addressed in a timely fashion, you can just imagine all the problems that happen over months while somebody isn't getting financial support, while somebody, isn't having their parent and child situation addressed. And so that's been really a huge problem during the course of the pandemic, is those, longer term motions, those matters that are going to proceed eventually to a final judgment, where they're not addressed in the meantime. That's the real heart of the problem of what's going on in terms of the backlog, and that's what we hope will soon be improved. And that's something where, again, in the meantime, while that's improving, there is a more vigorous emergency motion practice, and Jennifer's Law gives more tools to see, okay, how can we use now some of these coercive control issues, the financial issues, and even restraining orders have components for custody, they have components for finances. And, that's something where, if you can't get into court in the long term, you should explore what you might be able to do on an emergency basis, especially under Jennifer's Law.
And then especially with, I was gonna say, just with filing for a restraining order, you have to do that in person at the court, but you'd be able to file for a remote testimony. So if you're not capable of getting out to court that day, maybe you don't have transportation, maybe you have children that you take care of, maybe you're, the sole care provider at your home, and you won't be able to spend a day in court. You can file for remote testimony, and that can be faxed over to the clerk. So they're really trying to make it more convenient with this COVID backlog and make sure that everyone's needs are met.
And I just want to add to that I don't want to, it's a comfortable equilibrium, though, where, you don't want to have the emergency docket so swamped with motions because nobody could get anything else heard. You still need to have it there for, the emergencies. So, that's also part of the problem here is there are so many now emergency motions and people putting emergency in front of anything that it then, threatens to swamp that docket. So that now is part of the problem. As well. Everything now is captured emergency, not everything, but, it's a way to get into court, where, again, that's part of the problem that, we're trying to help sort out with the judicial branch.
Right. Hopefully once that opens up. Real quick, too, Colette, we had talked about this. I was able to put this in the web story, but it didn't make the television aspect. But, it's important to note that a victim can be a man or a woman, and that you've actually had, someone file under Jennifer's Law who was a male. We do want to note that too.
Yes, so survivors of domestic abuse can be male, female. Abuse has no gender. It's really about making sure that your rights are being heard, coming forward, finding some support systems that you can trust, maybe family members or a therapist you can confide in, or, CCADV has a 24-hour hotline. So if you even just, hear this story and have questions, make sure that you reach out and get some help.
All right. Alex CUDA,
Colette Donnelly, thank you so much for again taking more time to delve into this issue. I'm glad we were able to have this discussion.
Absolutely. Thank you for having us.
Appreciate it.
Thanks for having us. Thanks for your work on this.
You're welcome. All right, coming up, we get a bird's eye view on how new laws like Jennifer's Law get implemented with Associate Professor of Criminal Justice at the University of New Haven, Mike Lawler. That's ahead.